Good evening or good afternoon. I can't always quite remember what 6 o'clock
Yeah.
counts as, but anyhow, good day. I am as ever Hermann and I'm joined by the ever awesome Sara Gon as we approach the end of our look at the rule of law in South Africa, what it consists of, whether it's present in South Africa, its hopes, its ambitions, its future, its past. And that is, of course, what the Taking the Stand podcast of the Freedom Advocacy Network has been about these past few weeks. And we are now in the penultimate episode to look at the final point where we, in our final episode of this series, perhaps will give a whole, feedback on the thing. But the long and short of it is that we have now arrived at point 8 of what the rule of law is considered to consist of. So to quickly run them through: number 1, accessibility; number 2, law, not discretion; number 3, equality; number 4, exercise of power; number 5, human rights; number 6, dispute resolution; number 7, fair trial; and number 8, compliance with international law. So, Sara, let us get down to the definitional aspect. It's where we're treating this a bit like a piece of legislation. You get the long title, that's what I just gave, and then you're into the definitions. So, definitionally, international law, what are we to make of that concept?
Okay. Generally, what perhaps the best example to give of international law is law. For example, law that comes out of the United Nations, if not law, sort of resolutions or the decisions of bodies usually that are aligned to the United Nations. So it could be medical, it could be related to our obligations under the International Labour Organization, which we have essentially signed up to. So in other words, we cannot create legislation that is any legislation that we create that is contrary to the ILO's provisions would be considered wrong, basically, and we would not. A court would not be able to find against a provision of the ILO in a South African court. So that's the best way of generally putting it. There is customary law, and I'll give you, for example, the most probably well known is the right to indemnify visiting foreign heads of state against any action that may be taken against them for any reason. It's usually human rights related, but it could be something else. And it gives them a protection to attend as in their capacity as the head of state for the purposes and the benefit of their own state. And the other thing could be treaties, they could be agreements on climate. It's a wide range, and the Constitution provides that the courts of South Africa have to take into account our international law obligations. Foreign law, as in the law of other countries, we may consider, which we often do, when courts make decisions on points on which usually we haven't got well-established law, but there's no obligation to find, say, example, what America says about an issue. We're not obliged to follow American law.
Yeah, no, I must say that I remember from my first year law student days, I was never quite clear what the difference between foreign law and international law is, because section 39 or 38, I can't remember, section 38 or 9 of the South African Constitution says exactly that you may take foreign law into account, but you must take international law into account. So foreign law, one can see as, examples of other people doing something. International law is a law that applies to multiple countries, one of them being our own. So exactly as you say, the treaties, usually there's some United Nations component here. And perhaps speaking of the United Nations, one can't get away from the fact that there's some politics. Like there is politics in the making of national legislation, there's politics involved in the making of international legislation, and South Africa's political position in the United Nations or the League of Nations, as it were, its slightly failed precursor. It's always been a bit tenuous, so or testy, to see whether we are in line with it. Of course, since '94, things have been a bit different, but perhaps it would be prudent to ask, historically speaking, looking back to 1994 and before, perhaps 1993 with the interim constitution, was that obligation within the constitution to adhere to international law. Would it be fair to say that was inserted into the constitution because of South Africa's past of, not always submitting itself or adhering to these norms of international law?
Well, essentially, apartheid would have been your classic contravention of international law, and this is where the politics comes in. Is there are heinous regimes in various parts of the world who treat their citizens appallingly badly, and theoretically should receive some of the opprobrium that South Africa received for being an apartheid state. But apartheid was declared a crime against humanity because Russia, together with its supporters, managed to get that resolution passed in the UN. So, as such, they could suspend. I don't think they ever terminated, but suspended South Africa's membership of the UN, which was quite a thing when you think that South Africa was one of the founding fathers, so to speak, of the UN. So that's where your politics comes in. The reality is you have to have something as severe as that to attract enough opprobrium to actually be punished in some way for it. But it's actually terribly difficult in reality to punish states for their contraventions of international law, unless somehow you can attach some sort of monetary value and sue them for it in some other jurisdiction. That's the problem. And to give you perhaps a better example of where customary law got overtaken by a United Nations resolution is when Omar al-Bashir came to South Africa for the AU summit some years ago. And the customary law was that he was entitled to indemnity or to be covered with diplomatic immunity despite having being charged with committing genocide in Darfur. Now, the majority opinion on that was that there was a Security Council resolution that because the Security Council had referred that issue to the International Criminal Court, it overrode the customary law. So it gives you a sense of how both worked. And we are a member of the founding member to the Criminal Court, the Statute of Rome, as it's called, and it's in terms of that our obligation arises. It's very difficult for the UN to do anything about a country that isn't a member. So that's always the limitation, or one of the potential limitations of international law.
I must say, international law is this weird creature because in usual national legislation, you've got the trias politica, or the three branches, as it were, of state. You've got the lawmakers that can gather to make the law. You've got the executive to apply the law, and then you've also got this extra component of the judiciary making sure that the law is applied sensibly. And there are these checks and balances. International law is a bit weak on all of those fronts because the mandate to make the law isn't perhaps as strong, but it's still considered to be binding. The international criminal, executive idea is, thankfully, there's no supranational executive idea, but it sort of has this obligation on the national executives. And then you've got these almost international type courts. The problem is that you can either submit or not submit yourself. So that does make international law a bit weaker. And perhaps to add on a little tail to that, is that good or bad for liberty and freedom, do you think?
Well, it depends. One could say it depends on the issue. But for example, where you have in a democratic state where you're accountable entirely to your electorate, it is the electorate that determines whether you're in power. The fact that decisions can be made for or against you as a government is quite powerful, and it's absolutely binding. Now, if, for example, I gave the example of the sort of political side of the UN. If you have a resolution, let me perhaps give you the example. it doesn't exist at the moment, but it existed for about 12 years, where again the Russians with their allies declared Zionism to be racism. Now that had all sorts of political motives. It wasn't about anything more glorious than that. And its strength lay not in the fact that much could be done about it, but those who favored the resolution could then make a large sort of issue out of it, a global issue out of it, which then, of course, had to be lived with and dealt with, but there was no medium by which a final determination could be made until the UN agreed to withdraw the resolution.
So this flimsiness, I mean, it's exactly as you say. It could be in the service of liberty, but it can also be quite undermining of the idea of nations and nation states specifically. But I mean, I do think it's fair of Lord Bingham to include compliance with international law as one of those markers of the rule of law, and that is why the al-Bashir situation was so troubling here in South Africa about almost a decade or so ago, when this person accused of war crimes in his own country came to South Africa. South Africa being a signed up member to the relevant authorities looking to prosecute this man, and then the government of President Zuma choosing not to comply. That was why I think the rule of law was so tested there.
Well, you see, the criminal court required that he be arrested in signatory states, and we didn't arrest him. We somehow allowed him to come through and go out again. And that did not do South Africa's reputation any good. We suffered badly from that. There wasn't much that the court chose to do. Even if it could, it probably can levy a fine, which isn't very helpful. But it was basically saying, you know, you can't pick and choose. You can't pick and choose under international law who you will arrest when you're ordered to do so, and who you will not arrest despite being ordered to do so. So it has very often, mostly, a very strong political issue where there can be of benefit. For example, take the International Labour Organization. No one may not agree with it all, but it all basically looks to the protection of employees, that employees should not be exploited or worse. The fact that to some extent individual states may choose slightly different paths to what is laid down in international by the International Labour Organization, provided it's not way out of the bounds of it, it generally has benefits. So you sign up to the ILO, it means you are going to undertake to provide the protections, at least as provided for by the ILO. So it's really is one hand, the other hand depends on the circumstances.
So with the you know, looking back at history and seeing South Africa falling foul, especially during apartheid, of international law norms, and considering the past 20 or 30 so years, where it seems to me at least that we've been more in line with international law, but not perfectly so, especially with that terrible business of letting a war criminal go. What do you think is the state of affairs as of 2021 and looking ahead, perhaps specifically taking into account domestic policies like expropriation without compensation? Because we look at the UN Charter of Human Rights, you look at, you know, international treaties, the Free Africa Trade Agreement, and you can't help wonder whether this collision course of domestic policy versus international law commitments, whether that wouldn't cancel one or the other out, both to the detriment of citizens and freedom.
Yeah. Well, essentially, when you have, I think you can safely say, when you have a government that is seeking to limit rights, and expropriation without property is, without compensation is a limitation of property rights. Now, Governments can take that route if they choose to adopt a more socialist approach to the governance of their countries. But the point is, it's usually a sign that if that right's going, other rights are going to go, and we're starting to see that. And that's when the country runs a risk of contravening international law, but the desperation of the political body in charge is usually going to override. In other words, they're going to carry on going, and they would probably have to commit genocide to really get the attention of the international community. What they will get, for example, where you limit rights, is you won't economically, the chances are your economic benefits will gradually move away. Other countries will not invest. So it'll be more a sort of practical response by individual countries than it will be by the international community. Because the one thing the international community, the international law can't dictate is what type of political system you have and what theories underpin it.
Yeah, no, I must say, so it's on many of these issues that we've been looking at over the past few weeks, you can either score South Africa a clear pass or a clear fail. The international law one is a strange one, because it's like it's like we're going for the SIC test or the supplementary exam. We're not blatantly failing it, but we're not passing either, and that's perhaps something to look at, and something that I think citizens might sometimes underestimate is there's no, I think, knight in shining armor coming over the horizon of foreign lands to save South Africa. But that does not mean international pressure is meaningless. That does not mean international law is meaningless. That does not mean making your case internationally on the basis of international law is meaningless. So perhaps a parting shot question. Do you see a route that a citizen, someone supporting the work of the Freedom Advocacy Network, a fan as it were, do you think that there's some way where the idea of international law might not just be some abstraction somewhere, but might become a tool to advance freedom here in South Africa?
Well, I'm so just trying to think of the example, but I know there have been a couple of bodies, of citizen-based bodies, that have threatened to go to international forums over issues like expropriation without compensation. Even although this is a real stretch, the murder of farmers, trying to categorize it as a genocide to send to the International Criminal Court. Now, they may sound a bit of a stretch, but those fora are open. If for an organization, it doesn't have to be just a country, but for an organization to try and get some support effectively through a body like that they're not making headway with locally. But it's a fairly rare and difficult thing it's a difficult thing to do. It's costly, it's time consuming, and you do take a hell of a chance. But certainly that's a sort of perception of rights being abused, that if you can couch it in the terms covered by bodies like the court, you could take it there.
Yeah, so to end off with one of I think a useful soundbite that have come to mean something for me is that rights and freedom, underpinned by those rights, only as strong as citizens are willing to make them. So whether it's international law, domestic law, or just plain old good politics, what I can say, and with that I end this episode, what we all should agree on is that justice should be about freedom, and your freedom is worth fighting for. Thank you very much, Sara, and everyone at home. We'll see you next week.